Back with us here on the Newsfeed late night tonight under the spotlight, the work of the judiciary, their position in the Constitution, the ecosystem in which they function, and the role of the Judicial Services Commission in holding judges accountable. Joining me tonight to unpack this conversation is attorney and coordinator of the Judges Matter campaign, Alison Tilley, founder and executive chairperson of Democracy Works Foundation, William Gumede, and the chairperson of the General Council of the Bar of South Africa, Craig Watt-Pringle. You can be a part of this conversation tonight by tagging us on Twitter at Newsroom405 and WhatsApp your questions and comments to 072-110-5584. Good evening to you all, and thank you very much for your time tonight here on the Newsfeed Late Night.
Hi.
Evening.
Hi, thank you for having me.
Craig, I'll start with you. I mean, what we have been experiencing the whole day, and we've just played deliberately now about 10 minutes or so of that. What does it mean in a constitutional democracy like ours to have the appointment of judges being done in such a transparent manner?
Well, I think the clue is in the word transparency. The Judicial Service Commission represents a radical departure from the way that things were done in the era of the previous government. That is to say, pre-1994. When, frankly, the way in which judges were selected was entirely lacking in transparency. And I think it was largely driven by the judges' presidents who would recommend judges to the minister, and then the appointment took place. I think that in a country as diverse as ours, where we also have the objective of a diverse and representative judiciary, it is important that every appointment is subjected to scrutiny and in the public fashion in which this is done.
Does that in itself, in a sense, guarantee accountability? You know, sometimes it is said that judges who are appointed by a particular regime become loyal to that particular regime, and therefore decisions are made in favor of the regime. Does the fact that judges were appointed in such a transparent manner to all divisions of our courts give us a sense of assurance and guarantee that the judges will be held accountable?
No, not necessarily. Well, I think you're asking two questions. The one is, or implied would be, does this transparent process necessarily result in the right appointments? I think that is not necessarily the case, but at least the transparency means that the Judicial Service Commission itself is held accountable for the appointments that it makes, because everybody sees the process that unfolds. As far as accountability of judges is concerned, I think that's an entirely different issue, and that's where the disciplinary role of the Judicial Service Commission comes into it.
Yeah. Alison, the fact that these norms and standards of operating have almost been ingrained in our way of doing things, how judges are appointed, and there will be parliament, and there will be, of course, other fellow judges or peers or advocates in that, and people who know how the law should function, participating in this particular process. Does this in any way serve in the greater purpose of what we're trying to achieve as far as the standards that need to be set for our judges in the country?
I think it should. I'm not sure that it always does. I mean, one of the questions that I would have about the JSC and its functioning is really to what extent has the JSC articulated the criteria that it uses when it appoints judges. I think sometimes you'll hear that in a question, but it won't necessarily be repeated. One of the justices asked a question earlier which went to criteria, but it hasn't been asked again, Justice Petty. And I think that that's perhaps one of the things that I'm interested in interrogating in the way the JSC questions its candidates. So what exactly is it looking for? And is it the same thing at every level? And surely a constitutional court judge would be different from a high court judge in a small province. I say that without knowing the answer, because there isn't really an articulated sense of criteria. That would give us more of a sense of what kind of judge they're looking to appoint.
there is something called institutional independence, or in some cases called decisional independence. In other words, the separate branches being kept separate to avoid improper influence on the courts from the other branches of government. I mean, what we have been seeing in the country is a narrative that seemingly seems to suggest that the judiciary is actually the one now having influence in the other functioning of the other arms of government. How true is that?
Well, I think it does have an influence, and it's not an improper influence at all. The whole idea of having a constitutional democracy and having the oversight of judges and who uphold the Constitution is to make sure that the other branches of government play by the rules. They're rules that apply to all of us. They're known to all of us, or can be if we're able to get a copy of the Constitution, which is another discussion. But once we know what all of those rules are, the idea is that we stick to them, and if we don't, the courts are there to help us make sure that we're treated fairly. So I don't think it's a wrong thing that the Constitution is used by judges. You've also got to remember that judges don't just go out and tell people what to do. People approach the courts. They come to the courts with their problems and say, please, will you solve these problems for us? And I think, at that point, it's perfectly proper for the court to say, well, there's a constitutional right involved here, and this is how we're going to decide it, given that.
Professor Gumede, there is a process underway, and it is supposed, in a sense, to ensure that the judges who are appointed are appointed in an open process and the public is aware of what's happening, because ultimately, as the Chief Justice once said, the judges are ultimately accountable to the people themselves. Has South Africa ever thought of a process of judicial elections? And would you think that would be a good tool to use in the appointment of judges, as opposed to this process where we are pinning our hope, I suppose, on the parliamentarians to hope that they make the right decision?
Firstly, I think it's quite important that we have this transparent process of interviewing, and it's in the public. I mean, that's very important. But, it is not foolproof. We've seen it because, politicians are involved. If you remember, the transition, when Judge Mogoeng was appointed as a judge president, a controversy there, because the then, deputy president of the Constitutional Court, Afrika Thabo Mdluli, very experienced, was sidelined because he was critical of the ANC and critical of the current then president. So clearly, we've had, over a couple of years now, really a battle between the executive and the judiciary. And I think the issue is, quite a number of ANC leaders do not understand, or maybe, or even if they do understand, does not accept that this is a constitutional democracy. It's not a presidential democracy. Neither is it a parliamentary democracy, and that the courts, and the constitutional courts, as the apex, do hold people accountable. But having said all of that, it also would then be very important, that the judges themselves are held accountable by their peers, or, in our case, the JSC, that they do hold judges accountable. Because if you're in a constitutional democracy where the judiciary plays such an important role, it is going to be really important that, they have impeccable credentials, that they, in their behavior, whether it's in their public or private behavior, and, in their decision-making, that is above board. And because if that's not the case, it undermines the courts, and it undermines the judiciary.
Yeah, but in terms of the process itself up until this far, I mean, is there a need for us to relook this process?
I mean, the process, of course, is not perfect. I mean, what I would have loved to, in a perfect world, is it possible to get the politicians, or at least reduce the makeup of the politicians, in their setup, And secondly, bring in perhaps more civil society, as part of the mix of the JSC in the interview process. And I say that's in an ideal world. I mean, that would be my view. And then secondly, for much more stricter accountability of individual judges. I mean, we've seen now the last decade controversies of, the way judges behave. I mean, we had a situation, where one judge was accused another judge of, of slapping or hitting their judge. That sort of thing is unacceptable. And, a judge accused of those sort of things must immediately leave.
Yeah. Craig, what's your feeling of that, the less involvement of politicians and bringing in more civil society in the selection process?
I absolutely endorse that. I frankly don't see why politicians should play a significant role in the appointment of judges.
And I mean, there is a sense somewhat coming out of the various deliberations that are happening. For example, the former president saying, no, we had a secret meeting in my home ahead of your appointment, and whether or not they will constitute conflict of interest and such things. And these things have got people worried to say, are there such meetings that are happening between members of the judiciary and those who are in the executive? And what does it really mean ultimately when it is the president, I suppose, that will decide on these appointments?
Are you asking me whether such meetings take place? I have no idea whether such meetings take place. I have no reason to think that they do.
Okay, and if they did, I mean, what would it mean?
Well, if meetings of that nature took place, especially with the president who ultimately appoints the judges on the recommendations of the Judicial Service Commission, that would be a matter of grave concern. But of course, one would only say that if the meeting was in close proximity to the appointment and had something to do with the appointment. If there was some legitimate reason for a meeting that was unrelated, then that inference wouldn't be reasonable.
All right, Alison Tilley, William Gumede, and Craig Watt-Pringle still with me. We're looking at the judicial accountability tonight here on the Newsfeed Late Night. Let me get your views on these things at Newsroom 405. WhatsApp your questions and your comments to 072 110 5584. We're back in a moment. Live now on the Newsfeed Late Night, judicial accountability under the spotlight tonight at Newsroom 405 on Twitter. Let's get your views on 072 110 5584. That is the WhatsApp number in which you send us your comments as well as your question. So, Alison, I know I started in the end because, of course, we were coming out of those interviews. But let's take it back now to the beginning. The peculiar constitutional position, unpack that for us, in which our judiciary find itself and the conventions that are in place to ensure its independence.
I'm not sure that the judiciary do find themselves in a peculiar position. I think that there are three arms of government, Parliament, the executive and the judiciary, and the judiciary are there to make sure that everybody sticks by the rules. It may seem sometimes as though the judiciary have more power than they should have. People are concerned that, for example, judges make law or judges, aren't elected. But I think those are concerns which if properly ventilated, really just show that sometimes people don't like the decisions that judges make. But they are often the first people who will run to court if they feel that their rights have been violated. So I think, what's good for others, what's good for me is good for others. And we have a very robust judicial system, and I think one which is highly respected. And obviously there are concerns about that respect being undermined at the moment.
Talk to me then about those restraints. I mean, we saw some letter doing the rounds saying, well, these number of judges who are sitting there on this bench will make a decision on the political career, for example, of an elected person. They are not elected. What are the restraints that have been placed on the judges to ensure that they remain independent and not influenced?
Well, there's a whole slew of restrictions, and we'd have to spend quite a lot of time unpacking them. But they range from the Judicial Code of Conduct through to the fact that judges can only judge within the law, on the law as it exists. And I mean, obviously there are exceptions, but most judges in most courts will spend their day trying to apply the rules as they exist. For judges, there is always the question of appeal. Judges are in some ways held accountable through the appeals system. If you get it wrong, you'll get overturned. If you get overturned too often, then that also becomes an issue. And then there's the system of accountability that we have within the JSC, where you can lay complaints, and then those complaints, if they're serious, are taken up. That is a system which is new, in legal terms, relatively speaking. It's 20 years old, but nevertheless. And that system is also used to hold judges to account. So in many ways, they are really tightly constrained by the role that they play, the ambit of what it is that they can and can't do. There's a famous phrase which is where they say judges have no purse and they have no sword. They don't have budgets. They don't have an army. What they have is the law, and that's what they're there to do. And I think we can be we can be very proud of our judiciary as they stand.
All right. Let me dip out of this because happening now, of course, our reporter for Newsroom Africa, Channel 405 on special assignments, Diane Hawker, is outside the Judicial Services Commission, where today they've started interviewing 88 candidates vying for 31 vacancies in the country's courts. Diane, good evening and thank you for your time. It seems the interview process has wrapped for now. However, there are meetings still continuing there. Do tell us more. What are we learning? What's the latest?
Thank you, Thabo, and thank you to you and the viewers for sticking with this process. It's been quite a long day here at the Judicial Service Commission. Interestingly, the Commission had actually anticipated to spend an hour on each candidate and had very optimistically put on their schedule that they plan to wrap at 20 to 6. It's much later than that now, and as you can see, some members of the JSC are still having a meeting. What I understand is that they are discussing one of the key matters that has recently emerged, that of the issue against Judge Hlophe, that conduct tribunal having decided that he was guilty or is guilty of gross misconduct. So some of the commissioners have left, those who are from the National Assembly, and the remaining members are those who are with lawyers or the judges on the panel, and they are the ones that are actually discussing this conduct issue. As per the Judicial Service Commission legislation, they are the ones that are meant to then decide on that. It's not clear if there will be any outcome communicated as of today. We know that issue of Judge Hlophe has taken many, many years to resolve, and that decision came out just before that meeting, in fact late on a Saturday night, I suspect because the Commission knew that they would be discussing it today along with other important judicial matters. Thabo.
So what is the decision then, Diane, that is expected to be made now by the Judicial Services Commission after, of course, that outcome?
So, Thabo, the Judicial Service Commission will have to deliberate over whether it will accept the ruling by the tribunal or whether it will come up with an alternative view. Obviously, the tribunal's decision was a unanimous decision in relation to Judge Hlophe, and it set out its reasons for that quite clearly. So the Judicial Service Commission will then have to decide how it moves forward with that. The charge of gross misconduct is quite a serious one, Thabo, and it's one that can actually result in the removal of a judge. And that's really what's up for discussion now, is whether that is the step that the Judicial Service Commission will make. There has been also commentary to indicate that they are likely to also ask Judge Hlophe for any additional inputs. We are yet to hear from his legal team as to whether they will take the issue on appeal, but the Commission will be discussing that at the moment to see what their next step is.
And what does it mean that a judge will be removed? I mean, in its actual sense, it means he will no longer be holding any position in our judiciary at all, even in the foreseeable future?
Well, Thabo, if a judge is impeached, as is the possible outcome when it relates to Judge Hlophe, then you wouldn't have a job anymore, essentially. Judge Hlophe would then be removed from his judicial position. I wouldn't want to speculate on which way the JSC is going to go, but in terms of the Constitution, gross misconduct is one of the three mechanisms with which a judge can be impeached. So we will have to wait and see for that outcome as to whether the Judicial Service Commission decides to go with that impeachment option, Thabo.
As far as the interviews are concerned, Diane Hawker, what do we know? What is the next step or next phase in that process?
All right, well, Thabo, just before we go to the next step, I think it will be important to reflect on some of the interviews or some of the discussions that we had today for some of the viewers who might have missed the earlier portions of the day. At the start of the day, we saw one of the candidates pulling out, that's Deputy Judge President of the Gauteng Division, Judge Ledwaba, saying that he would actually rather be interviewed for the Supreme Court of Appeal. This is because he actually was nominated for both the Constitutional Court and the Supreme Court of Appeal, and in fact he's been acting as a judge of the Supreme Court of Appeal since 2019. So quite a long acting stint there. Most likely he's thinking that he's got more chance of a success considering the amount of time that he's actually spent at the SCA. After that, we then heard the interview of Advocate Alan Dodson. Advocate Alan Dodson is a practicing advocate here who came to give his interview today. And he actually was previously a judge of the Land Claims Court for 5 years and then went back to practice. And he spoke about what his experience both as an advocate and a land claims judge could bring to the table. One of the sticking points was his experience and the fact that he hasn't recently acted as a judge in any of the courts, but he said that he's been doing a variety of judicial work, including being part of a UN panel that decided on land issues in Kosovo, and that he did other work that actually could be considered judicial work and that he should be considered favorably along with the other candidates. We then saw Judge Faiza Kathri Sitlwane, who had, in my view, quite a tough session here with the Judicial Service Commission, a repeated issue coming up regarding her temperament as well as how she was received either by other colleagues or clerks that she's worked with. It was also an issue of a previous interview that she had, Thabo, and I seem to have followed her into this session. We heard some of the commissioners, saying that she came across as cantankerous. Commissioner Malemo saying that she came across as condescending, and she hit back at them saying that that was not the case, but that she is firm, and in fact saying that if she was a man, she wouldn't have been getting these same kind of questions put to her, that oftentimes male judges are cantankerous or can be seen as firm or stern, but they don't get questioned about that. The last session that we had now, Judge Jody Collopin, we know him to be a former human rights lawyer as well as a former commissioner for the SA Human Rights Commission some time ago, was also involved in the TRC process. And his interview really did look at his approach to transformation. But interestingly, he was also asked about the fact that some of his judgments, about 50% it was put to him, were actually overturned on appeal, which is not a very good record to keep if you are intending to go to a court that will also decide on other people's judgments. So looking forward, Thabo, we are expecting to see 5 candidates interviewed tomorrow, and then after that the Judicial Service Commission will meet probably late into the night once again to then decide on the commissioners or on the candidates, the remaining Constitutional Court candidates, before they start moving to other court posts. Thabo.
Dan Hawker, appreciate your time and thank you very much for joining us there with that report tonight. That's the Judicial Services Commission wrapping up in that process of interviews, as we are, of course, conversation with Alison Tilley, William Gumede, as well as Craig Watt-Pringle on exactly this process that is going on, but also matters of holding judges accountable. Craig, who should really have the right to decide if a judge should still serve as a judge?
Well, I don't have a difficulty with the Judicial Service Commission having that role, provided they perform it effectively and expeditiously. The recent finding in relation to Judge President John Schlorpe is a textbook example of something which wasn't handled expeditiously or efficiently. It's something like 12 years that it's taken to happen. I understand that, if I remember correctly, that at the outset the procedure wasn't clearly established, and so that gave some scope for procedural challenges and so on, which appear to have been exploited to the hilt. But if the Judicial Service Commission has a clear and expeditious process, then it's probably the right body to deal with this.
And how do we ensure we avoid that, I suppose, that improper process if we are to fix this process going forward?
Well, the Judicial Service Commission must be held to account. The Chief Justice is the head of the Commission, and he must ensure that these processes are put in place timelessly and that the timelines are set and adhered to.
Yeah. So the Chief Justice, I think in 2018, introduced something called the Judicial Accountability Session, which really was, in a sense, to hold the Chief Justice himself accountable, but also to hold the other parts of the judiciary in terms of their broader activities accountable. How was this process handled, and you think it's the correct way it was handled, and part of the work of the Judicial Services Commission? Should that be a part of what the Chief Justice reports on in these sessions?
Well, I'm not sure that he should have to report to the Judicial Service Commission. I'm not au fait with the process that you've referred to. I have no knowledge of its inner workings, so I can't really comment on that.
The Judicial Accountability Session, I suppose, a session in which members of the media and the broader public could pose questions to the judge, and he says this was a first of its kind put in 2018 and would continue from there, where the judiciary himself, as well as the activities of judiciary, would really be questioned on their level of performance and lack thereof.
I'm not sure that that's necessarily a good mechanism. You know, a major concern that we as the General Counsel of the Bar often had has been the kind of criticism that gets leveled against judges in open forum. And I think the rise of populist politics in South Africa has been one of the major reasons for that. I prefer the notion, as Alison Tilley mentioned earlier, the judges are held accountable through their judgments. They have to give reasons for their judgments. They are held accountable by possibly being overturned and sometimes severely criticized on appeal. And of course, if a judge is ambitious and as a puny judge loses too many appeals and in a manner which suggests that they're not competent or they're not applying themselves, that would be a career-limiting move. And I think in any event, most judges with the kind of background that most of them have in the legal profession, they take professional pride in their work, and so they want to be seen to be doing their work properly. But exposing judges to some kind of a free-for-all question session to me, sounds rather unstructured and a bit populist in and of itself.
Craig Watt-Pringle. Alison, I have a question for you. That essentially was put by Chief Justice Mogoeng to Judge Jody Colopin moments ago around the lack of capacity in judges in the Constitutional Court to carry out their functions. Is this a valid question? Are there real concerns there? But let's take a break. When we come back, I want Alison to give us her views on that question, and we'll get Prof. Gumede as well to weigh in on that. Let's get your views on Twitter, Newsroom405, otherwise on the WhatsApp number 072 110 5584. We're back in a moment. to the newsfeed late night. Judicial accountability under the spotlight tonight. Alison Tilley, William Gumede, as well as Craig Watt-Pringle with us tonight. You can be a part of this conversation. Tag us on Twitter at Newsroom405. WhatsApp your questions and your comments to 072-110-5584. Alison, it's a question that came from the Chief Justice being posed to Judge Jody Collopin. Judges who lack the capacity to function at a constitutional court level. Judge Collopin says, well, I didn't encounter that, but what I did find, for example, is judges with lesser writing skills than others. I mean, what is your sense of the capacity of our judiciary generally, but even at a high level of a superior court?
Well, I think that's one of the difficult things about being a judge, is constantly having your understanding of the law questioned. And I think lawyers are used to pretty robust debate. They are used to looking at their colleagues' work in a courtroom and explaining to a judge exactly why their colleague is wrong and why it is that they are right on the law. There's a very active academic debate about the law as it's pronounced on by the Constitutional Court. So I'm not surprised that there is a discussion about the capacity of Constitutional Court judges. There's a discussion about the capacity of judges and magistrates generally. Is that level of criticism a bad thing? Not necessarily. Robust debate around the law is important because the law is important. So we need to take those discussions seriously. I think what is meant perhaps in this context is something slightly different, which is where the Chief Justice perhaps feels a little unhappy at the level of criticism that has been directed at him or the court. I think that's one of the things that's you really need to look for in a judge, is somebody who has quite a thick skin, because that criticism is going to come. There's no doubt about that. And a really senior, experienced jurist who is confident in him or herself will be able to take that criticism with a pinch of salt and move on, because, you know, there's judgments to be written, there's cases to be decided, and I think that's really got to be the focus of the judiciary at the end of the day.
We are, of course, dealing with the matter now of the tribunal having made a decision on the matter of the Judge President of the Western Cape, Judge Hlophe, talking about the judge's code of conduct or code of behavior. What circumstances do you think we had imagined would arise when we came up with that code of conduct? And is that code of conduct still fitting? Or maybe is it something that we also still need to revisit?
I don't think there's anything wrong with the code of conduct at all. The code of conduct was designed to look at the question of independence, impartiality, conflicts of interest. One of the problems with the code of conduct may be that it hasn't been tested sufficiently, and that the JSC and the Judicial Conduct Committee in particular have not moved quickly on the many complaints that are now before them. The JSC in particular is supposed to report to Parliament once a year and give an indication of what's happening with the matters that it's dealing with, the conduct matters. The JSC has unfortunately not found itself able to lodge that report with Parliament, which seems unfortunate given that it's legislation that requires the JSC to lodge that report. It's not optional. So I think that's one of the things we'll be looking out for in the coming months, is a report from the JSC indicating what they are doing with the other matters that are before its conduct committee.
Professor Gumede, the judicial decision-making process has come under scrutiny in, of course, the latest judgments that have been coming out, because largely they've been touching on the political issues in the country, and many are saying judges are acting for parties or special interest groups rather than being motivated by the demand for the ideals of justice. Is this undue scrutiny, or is it relevant, I suppose?
Yeah, and before I get to that, let me just respond to something earlier about the capacity, of the judiciary. In a way, certainly there's almost a dual judiciary in terms of capacity in the country. I mean, there's the constitutional courts and the higher courts. They're fully capacitated, totally competent and competent. And then at the magistrate level, where unfortunately in many cases things, are not, capacity is not up to scratch. And often, ordinary citizens experience the magistrate courts, total chaos, and they don't get the kind of attention that they would get at the high courts. And I think that does influence and it colors the way ordinary people look at a judiciary. Because, for many people, there are two judiciaries, so to speak, the grassroots, the grassroots level for ordinary people that face, the magistrate courts first. They may often not have a very good view, of the system and the process. And just getting down to criticism of the judiciary by politicians, I think what has happened is that because over the last decades, the quality of our politicians and the quality of the decisions of political elites has been so extraordinarily poor, and the values, the moral values of our leaders when they make decisions, has been appalling. And it just means that, it is almost by default, the judiciary has entered into what would be perceived to be to make decisions which the politicians should have been made, but who the politicians are absolutely incapable. I mean, they're not capable. And it is ordinary people that take it to the judiciary, because, the political class, the ANC in particular, as the government, often has made such absolutely terrifying decisions against the Constitution, against, basic values, moral values, and so on. So that really is important. And then also, of course, the judiciary, like any other institution, needs to be criticized, and that's quite important. We have to have a dialogue, and we have to have criticism must be allowed. But I think what we've seen most of the times is populist criticism, and criticism where people are in the wrong, and they try to discredit the judiciary in a populistic way. So I'm here particularly talking about former President Jacob Zuma. I mean, what he has done, he and his group of people have attacked the judiciary, not on the merits of the law, but, specifically, to cover their own corruption and their own self-interested decisions, and so on. So one has to differentiate that kind of criticism from credible criticism, from criticism based on the law and on fact, and so on. So that is really important to make that distinction.
Professor William Gumede, Alison Tilley, and Craig Watt-Pringle, appreciate your time tonight and for your patience as we are, of course, tackling both the issues here tonight and what was happening at the Judicial Services Commission today. And that, of course, wraps up our conversation for tonight. The news.